Well, ladies and gentlemen, tonight we have a special honor in welcoming Justice Stephen Breyer, who is the 108th member of the United States Supreme Court. 108 members of our Supreme Court, and he's the 108th, and we're just honored that he would be here. I believe two have gone on to the court, Justice Breyer, since you have gone on the court in 1994, I believe. Justice Roberts, now the Chief Justice, and of course Justice Alito has just gone on to the court. So we're just honored to have him here tonight. Justice Breyer was born in San Francisco, 1938, a graduate of Stanford and Oxford and Harvard Law School. He taught law for over a quarter of a century, if you can believe it. He still is a very young man. As a professor at the Harvard Law School, at the Kennedy School of Government, he's worked as a Supreme Court law clerk for Justice Arthur Goldberg, a Justice Department lawyer and an assistant Watergate special prosecutor, chief counsel of the Senate Judiciary Committee. In 1980, he was appointed to the United States Court of Appeals for the First Circuit by President Carter. He became the chief judge in 1990. In 1994, he was appointed to the Supreme Court of the United States by President Clinton. He has written books. We will discuss one of those books tonight. Articles about administrative law, economic regulation, and the Constitution of the United States. His wife is Joanna. She's a British citizen and a clinical psychologist. They have 3 children. They live in Cambridge, Massachusetts, and Washington, D.C. And man, are we proud you're here tonight. Let's give a big round of applause. We're just very, very honored. I would first, if I could, this is going to be so informal, you can't believe it. We're going to start off just having a little chat here. I'm going to ask a couple of questions, and then we're going to sort of what you might call morph into a discussion with the audience. And this is going to be your opportunity to ask Justice Breyer. Don't ask him anything that's tricky, please, because he's not going to answer it. I want you to know that in advance. He's going to say, no, I can't answer that, but he will do his best to satisfy your longings for information and education about our Constitution, what the court means today to our country and to our system of government and to our hopes for tomorrow. And then finally, I'm going to ask him at the very end, I'm going to ask him, because we have a lot of young students here tonight. We have Supreme Court clerks who've been out at the state Supreme Court. We have young lawyers here this evening. We have many of the law students from UALR Law School. Our final question is, how do you prepare when you're at this young age to ultimately be a member of the U.S. Supreme Court? And you may not want to answer that, but you may want to go into that. But we want to say to you, because this is your first trip to Little Rock, Arkansas, first trip to our state's capital, and he's had a great day today going through the library, through the state Supreme Court. In the morning, he will be with our class at the Clinton School, then at the UALR Bowen School of Law class, the student body there, and we're just honored that you are here and wonder if you'd like to say a word, and we'll go from there. So we welcome you to Arkansas.
First thing is, I'd like to say how nice it is of you and of the law school to bring me here. My personal connection with Little Rock has always been Richard Arnold.
Yes.
See, Richard was ahead of me in law school. You know, the people who are ahead of you in school, they're giants.
I believe Kay is here. Is Kay here tonight? I think.
I did say before.
Anyway,
but the ones ahead of you are the giants. The ones behind you, you know, something went wrong. We don't know. But then Richard was in the Senate working on the staff, and I was there, and he was a friend, and really a very, very much respected judge. He was a great judge, great judge. And I'm so glad to have the chance to come here. I've loved this school. That's not just, he hasn't paid me to say that, but it's absolutely true. We had 3 students on the plane. I found out something of what they were doing. This railroad station is terrific. And what I think of as a former teacher, I mean, this building is beautiful. See, I can't answer your question. Just look out at that view. I go into outer space. But the fact is that when you go through that library, what I see is as a teacher, there's learning going on here. There's so much potential. I think of Philadelphia, where they have the Constitution Museum. They ought to have every high school student in the United States come through this with the interactive mechanism for learning about history, what is now history. I mean, you see current affairs being transformed into history right before your eyes. And the people have been very nice. And of course, judges, I talked to them.
Right.
I'm delighted the judges are here. And thank you for coming. And you know, judges like to talk to judges. There we are. But, it's been fun and interesting, and thank you.
Well, Justice Breyer, we really thank you for being here. One little question that it's sort of a human question. I've enjoyed hearing you tell the story a couple of times today about the day that in August of 1994 that you were sworn in to be a member of the United States Supreme Court, and also some days leading up till that time when you found out that you were going to be nominated for the court, to the court by President Clinton. Those are 2 little tipping point sort of days. I wonder if you could share with the audience about those 2 days.
When I was sworn in?
Yeah, when you were sworn in.
Yeah, I mean, that was in August. I'd been through this confirmation process, which is, mine was supposed to be smooth, but it was stressful. I think it's, you understand.
I do know.
But I mean, I'm on one side of a table, and there are 17 United States senators on the other side. That is not a relaxing experience. And I was given good advice. My advice was listen to the question, like you tell a witness. I got that very good advice from Michael Berman. He said, listen to the question, think about it, answer that question fully, and hope that the senator will go on to the next question. He did. He said, he said, your object is not to show you're clever. He says, your object is to be confirmed. He said, and when that senator finishes with his question, he'll ask the next one, he'll run out eventually, and you'll be confirmed. So, but this was somewhat stressful. So when I was confirmed, at that point, I wanted to be sworn in, so I picked up the phone and I discovered that Chief Justice Rehnquist was in New Hampshire having a vacation, Vermont, up in the northern part of Vermont. So I called him. We got in the car, we drove up there, and he was on his porch, and he swore me in. There we are. When I learned I was going to be nominated, that was a very moving experience, in fact. But I was in my office. I had not met President Clinton that year. We were watching television, my law clerks and secretaries and I, because they had said, and they said on the television, that the president is meeting with his advisors and is going to make his nomination selection this morning. So at noon, I think it was Bernard Shaw maybe, or might have been Wolf Blitzer, but I think it was Bernard Shaw. He came out and said, well, the president has decided to nominate Judge Breyer of Boston. I said, that's very nice, but I haven't heard anything. And then a couple of hours went by, and I thought, well, there we are, and it was very nice to be considered, and I was talking, at that moment, my Joanna called. She was in England. My wife is British, and her mother wasn't well, and she was in Britain with her, and she called and said, well, what's happening? And I said, well, I told the children that not to get excited about this. It's been a couple of hours. The television says something, but not a word. At that moment, my secretary came in and said, the White House operator and the president would like to speak to you. But he'd spoken the year before, and he had appointed a very, very great judge, Ruth Ginsburg, and I couldn't complain about that. Of course, it wasn't me. But I didn't know what he was going to say. And his voice was pretty strong, and I thought, this is a good sign. And then he said he did want to nominate me, and I was very moved by that, very moved by that. Emotional moment. after you go out, I went outside, there were a lot of press people there, which I wasn't used to. Indeed, I went home in my car, and we live in a little cul-de-sac, and it was totally filled with the press people, and I had nowhere to park the car. So I parked around the side, we went in, and then I'd gone down, Joanna came back, and some of the children who were taking the airplane, we were supposed to go to Washington, and we'd been invited to go to the White House, which was very exciting, of course, and the press were trying to, I mean, what was I supposed to say? I said, I'm a very big honor and so forth, but they seemed to want to ask questions all the time. So they were following us to the airport, and they all got on the airplane. But they all bought first-class tickets. I mean, I was paying for this, you know. I wasn't going to buy a first-class ticket. So I flew coach, and they were up in first class.
That's a great story. A wonderful story.
Yeah, well, anyway, there we are.
This man is for real, I can tell you that. See if you agree or disagree with what William O. Douglas of the Supreme Court said at one time, quote, "At the constitutional level where we work, 90% of any decision is emotional. The rational part of us supplies the reasons for supporting our predilections."
No, I mean,
anything?
What I usually, the way it feels, he's quite right that they're open decisions in many instances. Certainly not all, but the word liberty in the Constitution does not explain itself. It's a word, and you have to figure out the scope. But most judges, and I bet him too, he wants to perhaps overstate a little. Most judges, in fact, I think about all, when they have a really difficult question, have sources. The source is the text. Of course you read the language. History? Of course. And tradition? Precedent? Values or purposes underlying those phrases. What's the First Amendment really about? And consequences. How will it affect people today in terms of those values if we decide this way or that way? And I think people, judges, some emphasize the first four more. They tend to be called more literalists, maybe, or originalists. But they'll sometimes look at the last two, but they emphasize history, text, precedent, tradition. That's fine. I probably emphasize a little bit more the values and the consequences. You know, I think that the First Amendment values are universal and it never change. The values. But the world sure changes. The founders didn't know about the internet, I don't think. And they didn't know about television, so we have to work out how to apply these values to present circumstances. So that's the kind of problem, and I think those are the sorts of things that not float in and out, but you're working with this material. It's not determinative, but it isn't you're out in outer space doing anything you want. Absolutely not. So you're trying to shape the material and trying to reach an answer with these tools that you work with. Now where he has a point, but it's much more of a minor point that I feel than you might think, is when you're in the midst of a very difficult decision, and is affirmative action constitutional? Does the word liberty encompass the right to assisted suicide for a terminally ill patient? How do you feel about, not how do you feel, I already slipped into the wrong language. But you see, I'll say why, it is a sense, there's right. What about term limits? Were those Arkansas term limits constitutional? What a great case. I mean, the language of the Constitution, you have a phrase suggests that they could do it, and a phrase suggests they can't. You look up what the founders said. Madison said no, but Jefferson said yes. Story said no, or did he say yes? But in any case, you see they were very much divided. And you look at the precedents, you find some way and some another way. And it was a very close case, and we could have seen the judges there. They're trying in that oral argument, which was great, trying to reason their way to a conclusion with these materials in an area that's not completely determinative. Well, what about that area, that narrow area where you feel, well, This is such a close matter. I say, well, am I guided by politics? I get that question sometimes. I say, no, I don't think so. I don't think politics, are you Democrat, Republican? Are you popular or not? Or is this senator popular or that one? No. No, I don't think so. Well, what about ideology? Say, am I Adam Smith, free enterpriser, a Marxist struggle session lunatic? I don't know, but you know, I mean, ideology? No, I don't think so. If I catch myself on ideology, I say I'm not doing the right thing. We say, well, what about your background? Oh. Sometimes I catch myself thinking, well, San Francisco, public schools, 1950s, very tolerant place, not completely tolerant at that time, I'll tell you, but more than many, inclusive, open tradition, participation, words like that, egalitarian pretty much, not perfectly by any means. But I think, well, that's who I am. I can't escape. I can't jump out of my own skin. I can't deny my own experiences. After a certain number of time as a judge or living in the United States of America, you begin to have general approaches to things. What do you believe about this country? And does what you believe about the country internalized in your own background, and so does it sometimes make a difference? Well, you can't escape yourself.
Early in your book, Justice Breyer, you state that, quote, my thesis is that the court should take greater account of the Constitution's democratic nature when they interpret constitutional and statutory texts. When you say the democratic nature, is that your own nature, someone else's nature, the society's nature? What are you looking at the framers, their intent? What are you looking at the nature of the democratic nature when you talk about this?
Tempted to say in one word, the Constitution. And the reason I say it that way is one of the privileges and also responsibilities of a judge on our court is unlike a judge in the Court of Appeals, which is a fabulous job, by the way, or a trial judge, which are highly responsible jobs. But the separate and different thing I think about our court is that we, as judges, have a continuous diet of constitutional cases. There are a lot of them, not just a few. And the fact that there are a lot means that you begin to see or have a view of the Constitution as a whole. And you ask yourself, what is this document really about? What's at the heart of it? Now, three of us, Justice Kennedy, Justice O'Connor, and I, were at a meeting with Bartan Gregorian, who's the head of the Carnegie Foundation, and he was trying to work out, what do we teach high school students about this document? And they'd asked a lot of lawyers, what's the most important part? And various groups, some said, well, the First Amendment, free speech, and others said free religion, others said, well, equal protection, and some said privacy, and they had a number of different. Very few said the word that came to our lips and minds instantly. You ask us what this is basically about? It's about democracy. It's a document that creates institutions. That's what it constitutes. What kinds of governmental institutions? Governmental institutions so that every citizen can participate and decide what kind of community they want. They're the ones, through their representatives, who are supposed to write the laws that govern themselves. Now, immediately you have to qualify by saying, well, it's a special kind of democracy. It's not democracy pure and simple. It's a democracy that understands that democracies can tyrannize. And so it protects basic human liberty. There we have the First Amendment. Is that unimportant? No, it's tremendously important. But it's a certain kind of democracy. It's a kind that protects basic human liberty. It's a kind that understands everybody should participate. Inclusion is the word. And therefore, it assures a degree of equal protection and equal respect for every citizen. It says no group of people in the government should become too powerful, so it divides horizontally and vertically, 3 branches, state, federal, and it understands that everybody should follow what's called the rule of law. All right, there you have it. What I say is the heart of it, with the qualifications. Are the qualifications are important? They're critical. Is the heart of it important? Yes. That's democracy. And I wish people would understand that more and more, particularly the younger ones. I want them to understand it for 2 reasons. One, the most selfish reason, of course, is that they will then understand that what we're doing in the courts, particularly the Supreme Court, with all these very controversial matters, is we're deciding at the boundaries. We're not deciding what's good policy. We're deciding if this policy created by others goes too far off the constitutional rails. And whatever you might think about the cases, and people do think very different things, it's still at the boundary. And there's a vast area between where everybody agrees. It's up to the individual to decide what kind of city, town, state, nation he wants. All right, now that's the unselfish reason, and is the constitutional reason for wanting people to understand it, and this is what I really want to say to the younger ones particularly, is that that document foresees not just that you can participate, but that you will. You see? I want to say, you criticize the government, fine, criticize. That's your right, and you should. But go out and try to do something about it, and I can tell you not that you should go. I say to the 10th graders, you know, I can't tell you what you ought to do, but I can tell you, I think in my experience, that the system, this constitutional system, won't work very well if you do not participate in some capacity in community life. It can be on the art museum, it can be on the school board, homeless people, in the government, whatever ways you choose. But that's what the document's about. And of course, I am trying to tell them what to do. But don't tell them I'm telling them.
By the way, I think that most of you in this room may know that next year, for a 3-day period, we will have, and Stephanie can give us the exact date, we will have the Emancipation Proclamation in this building for 3 days. Now that is a milestone. That is going to be one exciting moment when we have that. I understand they're going to keep the place open 24 hours a day because people from everywhere will be coming to see that revered document. Dean Goldner, I think some of your students are here, and I think they may have 2 or 3 of the questions. So why don't we start off with a question or 2 if we could. Before we get one of those to the microphone, let me ask, if I could, the Justice, how you go about dealing with some of these justices that you don't necessarily agree with. We had the Brooks-Baxter War over here, fought out over here in the old state capitol. John Purefoy Gill could tell us about that. And I believe there was a shooting or a stabbing over there in the House of Representatives. Y'all don't do that yet, do you? Or is it, you're not doing that, are you?
I sincerely hope not. Don't. It's interesting because, of course, it's in the interest of the press to play up differences, but there are differences of opinion, and they're important differences of opinion. But it's also important to understand that 40% of the time we're unanimous. Those 5-4 cases you're always reading about are probably about 20%, and it's by no means always the same 5 and the same 4. You know, one of the unspoken rules in the Supreme Court with a case, and it works pretty well, you decide case A, all right, it's decided. And every people might have disagreed strongly on A, well, now it's time for B. And B is a new day. I like that rule. It makes good personal relations, and it helps a lot. And the personal relations are good. We have lunch most days when we're in session. I've now sat in that conference for 11.5 years, and I have never, in 11.5 years, heard a voice raised in anger. Never. Not in Bush v. Gore, not in Nebraska v. Cathcart, the abortion case, not in school prayer, not in any of those cases. Never a voice raised in anger, and I have never heard one member of the court in that conference room say something insulting about another, not even as a joke. It's very professional. And the law students, I say, well, you know, don't you feel strongly? Yeah, sometimes I do feel strongly. So what? Am I supposed to start shouting? I mean, please. And suppose I were to say, oh, I feel strongly. Well, somebody disagrees, say, well, so do I. I mean, what's the point of that? We're professional, and we understand that it's important. And the way to deal with an important matter is you think about it, you read the briefs, you listen to the argument, and you give it your best. And sometimes others agree, and sometimes they don't. If they don't, fine.
Very good.
No doubt.
A question?
Thank you for being here.
Yes.
I think the constitutional foundations of democracy that you're talking about help explain why you don't argue, because we all know that we have a part to play. And I believe that America is spreading that concept around the globe, and of course there were earlier manifestations of democracy before the American democracy, but I am looking for solutions in the war on terrorism and the global conflicts that we have periodically and certainly now. And I wonder if you have thoughts you can share with us about how we can improve our strategies for winning the war on terrorism, particularly with respect to some of our failed attempts that have moved their recruiting efforts farther forward than we would like, and the legal issues surrounding Abu Ghraib and Guantanamo and some of the other questions that we face as we try to combat the threat before we even know where it will manifest itself.
Well, I'm certainly not qualified to give you an opinion about the general problem of the war on terror, because, and I've learned over time, as I see a lot of federal judges here, I know, and state court judges too, judges normally don't express opinions on things that are pretty far removed from their area of expertise, and that's a good thing. A judge is a person who has a lot of power in a limited area. And you begin to express your views on something that's just been bothering you a whole lot. And the lawyers will sit there and they'll nod politely. And they'll say, how interesting, until they get out of the courtroom. And they'll say, my God, that, oh, gee. So you have to be careful about that. And because we're in areas about how to fight the war on terror, I'm not an expert, and if I did have ideas, I wouldn't share them on that. But really, you're interested in what is a general legal problem, and it's more than a legal problem. And how is it in this area where we have serious threats, and they are serious, and we have a strong tradition of civil liberties, and it is strong, and that's a very good thing. How are we going to approach these in the future, and is there anything I can say about that, which is more in my area of expertise? And now you realize, having disqualified myself on the first, it's a problem if I get too specific on the second, because I'm talking about a future case. But I'll give you something of an answer. And I can tell you a few things that I think are pretty universally accepted as the Supreme Court approaches cases that ask us to make this kind of balance. And there are such cases, and there probably will be more. That first, I think it's generally accepted today that in wartime, Cicero said, yeah, I know this, I've read this quote about 5 times, I've misquoted it 92 times. But he said, so when he said, I try it in Latin, I can't do it in Latin anymore, I forget already. But Mr. McCarthy, my Latin teacher, would have a fit. But there we are. He said, when arms speak, the laws fall silent. And that's a famous saying in the law. And I used to say, when the cannons roar, the laws fall silent. And then somebody pointed out the Romans didn't have cannons, so I didn't. But anyway, that is wrong, okay? It is absolutely accepted that that is wrong, that the Constitution is a Constitution for wartime as well as peacetime. Nobody says the Constitution falls silent. It doesn't, and it shouldn't, and it doesn't. So that's generally accepted. The other thing that I think is pretty widely accepted is that a lot of balance is built into this Constitution. Justice Jackson said, and Arthur Goldberg repeated it, the Constitution is not a suicide pact. And it's written in a way that allows a degree of balance. That Fourth Amendment doesn't say you always need a warrant. It says you can't have a reasonable search and seizure. Now, what happens if a policeman sees some woman being kidnapped in the street and brought into an apartment? Well, he'll go right in. And he should. So there are circumstances where that reasonableness, you see, allows a little flexibility in the need of security. Now, the question is when and how much? And there again, we know something. We know the country's made terrible mistakes, including our court. I think it's universally acknowledged that in World War II, we made a huge mistake when those Japanese citizens, 100,000 citizens of the United States, were taken from California and sent to camps in the Midwest. I can remember it. I can remember my mother.
To Arkansas.
Arkansas, we're some in Arkansas. A lot in Utah. I didn't know. Arkansas, too. And my mother, I can remember driving down the peninsula. I was pretty small then, but I remember her saying, this is a Tanforan racetrack, and that's where the Japanese were taken. And then they were sent east. And you'd be surprised who was on what side of that one. We were talking, you know, he really is. Earl Warren was one of the ones who wanted them sent. Great champion of civil rights. He said it was the worst mistake he ever made. The person who wanted to save them, J. Edgar Hoover. He said the FBI can take care of this. Very interesting.
Amazing.
But in any case, I mean, I'll go on for a while. If this interests you, I'm prepared to talk for about 2 more minutes on this. But that case came to the Supreme Court, and the Supreme Court, to its discredit, said that that's constitutional. And there were 3 dissents. Jackson, Murphy, and I think Roberts was the 3rd. But Jackson said, we're making a huge mistake. Whatever people thought, whatever it was General Clinton, the 6th Army, who said this was necessary in early 1942 when people were afraid that Japan was going to invade California. I was there. I can remember the shades going down, the blackout shades. And he said, Jackson said, maybe that, but this is 1944. They're not going to invade now. So what are we doing holding these people here? And Murphy wrote a great opinion. Murphy, whom hardly anyone speaks of. Well, this was a good hour for him. He said, there is no evidence that any one of these people is either a saboteur or threatens to be a saboteur. Show me the evidence. And they had briefs which said, we can't show you the evidence. Too bad, then let them go. All right? Fine. But the court came out wrong. And we know that now. So how do I know? And that's the question. That I won't come out wrong again. I mean, that's the hard question. And there we know the lawyers can help. Because the lawyers can at least ask the government when they depart from traditional civil liberties, why? And they have to give a reason. And they'll have to show a few facts. And the lawyers will say, why not? Why don't you do it this other way, where you can achieve your security objective with less restriction? And answers will be given to those questions. And we as judges will look at those answers, and we'll look at the information, and we'll try to see that this does not go too far in destroying traditional civil liberties, and then we'll cross our fingers and hope to heavens that we've decided this about the right way.
If I might, just on the flip side, in terms of not the Constitution not being a suicide pact, could you tell us also what we can do to promote our own defense?
I tell you what, let's do this. Let's come back if we have time for that answer in a moment, and let's yield right over here. I didn't mean to cut you off, but this gentleman has a question, please. Thank you.
Thank you, Your Honor. We've seen Justice Scalia at times be pretty vocal about his views on originalism and occasionally some legal issues. What do you think the proper role of a Supreme Court justice is when issuing regarding those topics?
No, there's nothing. You have, like any judge in any court, you can't go too much into individual cases. But over time, I think it's sort of helpful to try to explain, as I'm doing right this minute. I think it's probably helpful for judges at all levels in the system to try to help others understand what it is that we do. The Supreme Court is not the CIA. We're not a secret organization. And people often don't understand the role that judges play or that the system of justice plays in the American Republic. And that's important. So I've found, and sometimes Justice Scalia and I have been on the same platform speaking together, and we disagree about a number of things. That's fine. That's as it should be. But the audience comes away with an understanding of how we go about resolving our disagreements in particular cases, they begin to understand it, and I believe that they find the process reassuring. And,
Thank you.
Let's have another question, please. We've got the mic's open. Yes, sir, Doctor. Or Judge, go ahead. No, please, go ahead,
I
Judge.
think I can be heard,
Yeah.
I think.
All right.
In light of the fact that we are now in a global economy, a global community, what role does international law play, what role should it play in how the Supreme Court decides these issues that involve us, but they impact in a very large measure on how we relate to our neighbors and cousins and brothers and sisters in other parts of this world of ours?
That's a very good question, and it has two different parts to it. There's the really interesting, exciting part, which I think isn't that important, and there is the really boring part, which I think is enormously important. You want both? I'll give you the exciting part. All right, here's the exciting part. You know, I was on a panel, and there was one of these panels that we have from time to time about relations among the branches of government, and we had a congressman and a senator and a couple of professors and some other judges, and it was at the administrative office building, and we were talking about this slightly esoteric, a little bit inbred discussion, and suddenly one of the congressmen starts to say how terrible it is, really awful, that some members of the Supreme Court are referring to the decisions of foreign courts. And he goes on at some length. So after a while, I said, well, I guess, Congressman, you mean me? And he said, well, yes, actually, I do. So I said, well, let me explain to you. Let me explain to you what it is, why I refer to decisions of foreign courts. I said, well, since the end of World War II, I think we've seen more and more countries turn to democratic systems of government. They want to protect basic human rights. They have written constitutions, a little bit like ours, and they rely to some extent on an independent judiciary to try to achieve that objective. And they have problems that are similar to ours sometimes. And so if I see another human being called a judge, has a job like mine, has a document something like mine, and is trying to figure out how to apply it to a somewhat similar problem, why don't I read the decision? I might learn something. It doesn't bind me. Of course I'm not bound by it, but I might learn something. I thought it was pretty good. He said, fine. He said, read it, just don't cite it. Yeah, I thought that was a pretty good point. So I said, no, look, it's more than that. You know, retreating like mad. I said that now some of these courts in say, the former Soviet bloc are trying to establish themselves as courts more. They need a little help sometimes. They refer to our cases. The Supreme Court of the United States has a history that gives it a certain prestige, and we refer to them, and they go to their legislators who are trying to get rid of them all or something, and they say, see, you know, we have some prestige in the world here. We're referred to by others. And he said, fine. He said, write them a letter. He said, just, all right, but what's going on there? What I personally think is going on is that this problem of referring to other courts' opinions in the constitutional area came up in two highly visible cases recently. By the way, it's been done since John Marshall. It isn't any new thing. But capital punishment, the constitutionality of executing 17 and 18-year-olds, gay rights case, Lawrence v. Texas, in both the courts referred to foreign cases. Not as binding, but you know, they referred to them. And now I call it from my wife, who's a clinical psychologist. I say, well, she tells me there's a phenomenon called displacement. And the psychologist may know what I'm talking about. You're really furious at A, so you blame B. So I said, well, he's furious at the results in those cases. I can understand that. They're very controversial cases. Of course, there are two sides to those stories, and of course, people get upset about them who think they were wrong, and they do think they were wrong, and so now they're blaming foreign law, which I think is, all right, so that's why I say, very visible, very exciting, but I not think so. Boring and important? Go back to look at our docket, say 2 years ago. I just happen to have that one in mind. We have 80 cases that we decide over the course of the year. Between 6 and 9 of those cases brought foreign law or international law into play directly. Now, I say 6 to 9 because 3 were gone to Guantanamo, and I can put them aside as special treaties and so forth. But 6 about what? Well, vitamin distributor in Ecuador, wants to sue the vitamin cartel with one American member, but he's suing those in Holland for raising the price of vitamins. And he wants to sue in an American court under American antitrust law. I'm surprised he could get here. It must have been very weak because vitamins were so expensive. Still, he wants to come here. Does he have the right to do it or not? My goodness, in that case, a very important case commercially, and we have briefs filed by the European Union, by Germany, by Japan, by countries, and they were good briefs too. Not just something that says Germany thinks you shouldn't do it. Very analytic, very thorough, very good briefs. Or Intel, a company in Los Angeles, wants to get information from another company in Los Angeles. Can they use our discovery system? Well, we want to present it to the European Cartel Authority, which, by the way, tells us we don't want it. Can they bring this? Can they get the information or not? Or what about the trucks coming in from Mexico, where there are groups that say they're violating an environmental law? Well, NAFTA comes into play and says they ought to be able to. Or Mrs. Altman. Mrs. Altman has trying to get 6 Klimt paintings from the museum in Vienna, and in her view, she says these belong to my uncle. I'm the legatee. The Nazis took them, put them in the museum, but the museum is a state-owned museum, and can they assert immunity under the Foreign Sovereign Immunities Act? A very difficult question. I thought, the best precedent in a French court, a court of appeals from Paris, in the famous case there of Christian Dior versus ex-King Farouk. See, Farouk never paid him for the dresses. He asserts foreign immunity, and the French court says, hey, you're not king. You were king, but now you're in Nice. All right. All right. Now, you see the kind of thing we're getting? And there are more. There's the Warsaw Convention. There's the Alien Tort Statute, where they passed this in 1790 or something, and give you a right to sue when you're injured by pirates. Well, who are today's pirates? Maybe they're the torturing dictators of Paraguay. Or maybe they're not. And these cases are in front of us. They're becoming bread and butter cases. And it seems to me, by chance, I find this case in Paris. I hate to tell you, I don't want it spread around, but I do not know the law of every country in the world. And so I'll find those cases if my law clerks find them, and they'll find them if they're cited, and they're not likely to find them if they're not cited. And therefore, the lawyers have to be able to find them, and the lawyers can't find them unless they're taught in the law schools. Back to you, Dean.
There you
I say, really, all right. There we are. That's why you see, I say it's important,
Doctor.
And it's not all that exciting, but it's important.
Very important. Doctor, I believe you had a question, sir.
Mm-hmm.
Yes, in addition to my question, I'd also like to have you to pass the word along to your colleagues on the bench there that we'd like for them to come visit our fair city also.
I will.
Yeah, right.
I will. You may not all at once. We will get it. I will. Yeah.
My question
we don't
is,
want them all at once, so do we? No.
no. Other than the time that you have spent on the court, and I'm not referring to the presidential election of 2000, what do you think is the most challenging time that the Supreme Court has ever had in history from your perspective?
Good.
Oh, you mean not including the time I'm on the court?
Not including the time you've been on the court.
Well, in our lifetimes, if I go back, and here my judgment isn't better than somebody else's, but when I was a law clerk, I was working for Arthur Goldberg, and that was 1964-65. And I felt that at that point, what the court was, it was a court with a mission. I mean, my own reading of it or recollection, and I've felt that what I've learned since is it was a court that had decided in 1954 that the phrase, no person shall be denied equal protection of the laws, meant what it said. They said, here we have a phrase. That phrase means what it says. The purpose of that phrase was to do the very opposite of what's going on in this country. And it was the opposite. And there was, you know, a lot of de facto segregation, but in the South there was de jure segregation, and that wasn't the only place either, but it was embedded in the law. It was embedded in the law not just in one simple way, it was embedded in the law deeply in complex ways that are just like this rug put together, and you had to get out certain threads and not others. And my goodness, that was a challenge. And the Warren Court was absolutely prepared to rise to that challenge. That was the Warren Court. And think of the Fifth Circuit. My goodness. They were brave. They were brave. And they had to implement those decisions. But I think for the law, for the federal judiciary, for judges, that time, 54 up through the 70s, when the legal job, now you know, the job is not totally done, but the legal job became pretty well, or began to, they made a lot of advance, and that was hard. And it showed up all over the place. And that, I would guess, is probably the most really difficult time for judges in the federal system, certainly.
Yes, sir.
Judge Breyer, in any judiciary system, justice must not only be done, it should be seen to be done. Many would believe that delayed justice is no real justice. So how can the court help to reduce the length of time it takes to decide some of these cases?
Well, in our court, we're fairly current. That is, we don't hold cases over we'll finish we don't leave in June until the docket's clear. But we have a very limited number of cases. In the system generally, it can be more of a problem. And there are all kinds of different efforts to resolve this problem, or at least ameliorate it. And some of them involve, for example, what's quite now much more commonly used are systems of arbitration, systems of mediation, and I'll tell you what was, you were reminding me, I don't know if you've ever lived in the subcontinent, but there is a huge problem that we're trying to help with, actually, of enormous backlogs. And once you get into this backlog, it's hard but not impossible to get out. And so it's, we've seen a lot in the business community. They've moved more towards arbitration. There are also minor disputes that you frequently can go to arbitration. And I think of the subcontinent because they have this thing called a lock and dollet. And the lock and dollet was a kind of almost like a community effort to deal with minor grievances, bills, accidents, and so forth. And when I was in India, actually, but I think this brings this to mind. And I was taken to a place in Ahmedabad. Sandra was there too, the two of us. And they had a kind of room that you went into, and this, like a stucco building. And in this place, they had just opened something, it was mediation, but they called it the women's cell. And there were 3 women in that room. One was a psychologist, one was a social worker, and one was a lawyer. And they had queues of people coming in from the villages on the porch of this thing. And they would go into this room, and the question that was asked the woman who came in, that's what they called the women's cell, they called it, they said, "What's your problem?" Not who's at fault, not what does the law say, not shall we call the police, what's your problem? And then when they'd find out the problem, they would try to resolve it. Sometimes it required the social worker, sometimes visits to the family. Now, I love to tell that story because I say to when I say that to an American audience, I say, of course, we have the same thing, don't we? And I know perfectly well we don't. You say, and so, but in certain places, you're going to get me started because the subject here I like, and I think it's important. In New York, for example, I was at a place called Red Hook. And Red Hook used to be a really bad neighborhood in Brooklyn, and they have housing projects and so forth. And the New York state system has tried to turn some of those courts into social service delivery systems. It's a drug court. Well, let's punish people for having drugs, yes, but let's also have a program where we divert people if they're undergoing treatment and follow them up and see what you do. And then with the housing project, the housing court judge goes into that project. And he says, I want to look around here and see what the violations are. That's very active. But that's well approved in the community, and it's made a difference. All right, I'm giving you some examples. There are 1,000 different things to do, and there are all kinds of programs everywhere, and it's a very important and desirable thing to try to do a few.
Very good. Judge Wendell Griffin. Judge?
Mr. Justice Breyer, many people enjoy hearing you, Justice Scalia, other justices, when you come into our local settings. And it's wonderful because you allow us to see a Supreme Court justice in our flesh. Will the court ever allow the people to see its arguments televised? It was wonderful for us to hear Bush v. Gore, but we think it would have been not just good theater, but probably great education had we been able to see. And would the court ever bring itself to that?
Good question.
That's a good
Is that
question.
Judge, about televising the
Yes,
proceedings?
televising the
I
oral
see.
argument. And I think the answer is perhaps. I think probably it's almost inevitable. But I will tell you what I think are the pros and cons and why it's difficult. On the one hand, very much in favor is this would be terrific educationally. I think it is important that people understand how the court works. And I think of that case out of Arkansas, term limits that I was talking about. And I think, my goodness, that would have been just a terrific thing for the whole government, really, probably, if people could have seen the way that case was presented and the difficulty of it and how people are struggling to get an answer. That would have been such a plus. And moreover, we're in an appeals court. You know, we're a higher court. We don't have to worry about witnesses, and we don't have to worry about juries. So why not do it? Well, there are 2 or 3 things on the other side. One of the things that worries people is if it came into the Supreme Court, the television, would it be absolutely irresistible because of we're a symbol. So it would be in every criminal trial in the United States. And as you can understand, you have to worry about juries, and you have to worry about the witnesses in a criminal case who think that their neighbors will all see them on television. So I'm not saying that's a convincing reason. I'm saying that puts a question mark. Another thing that puts a question mark. Well, the oral argument is not really how we decide the case. It's important, but it's only 5%. And people would think it was the whole thing. And moreover, people, when they see a picture, identify with people. Don't you? You don't like identifying with an argument. The minute here I'm starting to sound abstract, people less interested in if I'm concrete and talk about a person. It's so interesting. That's a good characteristic of human beings. But I hate to tell you, as an appeals court judge or a Supreme Court judge, I've got to worry about the abstraction. And the reason I have to is because it affects millions of people who are not in that courtroom. So you see somebody, you identify, this is the good one, this is the bad one. But the people who are affected are not there. So that's a question mark. Now, which wins? I don't know. But every single member of our court is a conservative on this kind of point with a small c. Why? Because we've inherited, I didn't write that decision in Brown v. Board, and I wasn't there. But I've inherited this institution that has that terrific prestige because of what others did. It's so important to the country. And the last thing that any one of us wants to do is to make a choice. We're trustees. Make a choice that would hurt that institution. And therefore you get nervousness. Nervousness. Not a no, but nervousness. Now what's going to be the solution? In my view, the solution will be go slow. You heard it on the radio? Maybe we have a few more on the radio. Did it bother the court that it was on the radio? No. Was there any bad effect? Not one. Have we done it again? Yes. Let's do it some more times. And maybe even try, a few times with the television, see what happens. But you've got to get the judges comfortable with the idea. And they have to see that it isn't going to work harm before you'll get the answer, yes, which is what you want.
Good answer. Yes, sir. Thank you.
We hear a lot about the First Amendment cases, but with the increase of states coming up with different laws regarding who can get driver's licenses and the Defense of Marriage Act and different rules on marriage, do you see an increase in evolution and full faith and credit clause cases coming?
We never know what's going to come up. You're thinking what happens if one state approves the gay marriage and the other states don't, and then the people who were married in the first place move to the second state, and in the second state says we're not going to recognize it, and then they bring a case saying that violates the full faith and credit clause, and indeed there was an act passed by Congress called the Full Faith and Credit Clause Act, and that would come into play as to what that provides and whether that's constitutional and so forth. You want to know my answer? I haven't read any of those things, and I have no intention of reading them or becoming an expert until I have to. You see why? I don't want to answer questions like that. It's a good question. Yeah.
Floor is open. Yes.
Mr. Breyer, I'm sure you're aware that there's a group of law professors, I don't think any of these law professors, but a group of law professors who have floated a proposal about term limits at the Supreme Court. And it seems to me that on one hand you have the argument that you don't want people to stay up there in that fabulous building forever because they get a sense of their own importance and they're out of touch and whatnot. On the other hand, it takes a while, I think, I would imagine, to hit your stride on the court, to get to the point at which you really feel you're in command of what you need to do and have developed what you were speaking about earlier, your sense of the Constitution and your ability to put all these cases in context. And I'm interested in knowing whether you can comment on one side, both sides, what you think about that.
It's absolutely right, it takes time. I said, which I've said a lot, which is totally true. I was frightened to death my first year. And it's really 2 or 3 years before you get comfortable. And 5 years before, you know, you're sort of reasonably comfortable. And it does take time. Of course it does. And then someone asked me when I was in San Francisco, my brother is a judge, a federal judge in San Francisco, and I was out there and somebody said, I was in some kind of a thing where I can't remember exactly, but the press was there and said, well, what would you feel about a long term? You mean like 18, 20 years for the Supreme Court? Fine. You know, it isn't going to make that much of a difference. As long as it's a long term, what you don't want is people sitting there calculating what their next job is going to be. Absolutely not. And, but, you know, most judges are appointed to the Supreme Court age 50, 55, between 50 and 60 probably, some a little younger, but, and some a little older. But they're not going to calculate after 20 years. I mean, there we are. So if you had a long limitation or something, I think it would come to about participated in, not because of any ethical rule or something, but he'll misremember everything in his own favor. So I mean, that happens all the time. So, but what I think the issue in that case, see, was this, that there is an eminent domain power in the state, and the state exercised that to condemn some property as part of a plan to redevelop a portion of the city. Now, the Constitution says in the Fifth Amendment that no private property shall be taken for public use without just compensation. Well, it's about compensation. It's called the Just Compensation Clause. It's not called the Public Use Clause. It's called the Just, but still, you have to figure out, is this redevelopment project public use or not? Well, what Stevens says in that majority opinion for the court is you cannot take property from one private person to give to another. Of course not. But the problem in the case is, what about the mix? You know, you're going to take a railroad property, aren't you? You know, and property for somebody to give it to a railroad to use as a bridge crossing, or suppose you're going to build an Olympic stadium, you know, there might be private people there selling hot dogs, or if you're going to take an area of the city that's totally run down and wrecked and you want to rebuild it, you know, some of that's going to go into private hands to put in a house or a hotel or something. There's a mix. So how do you know when it's too much? When is this too much private? You know, too much. And there, what the majority said is, like many property cases or cases involving economic regulation since Franklin Roosevelt, you pay a lot of attention to the legislature. It didn't say the legislature can do anything. The judge is there to see if it's reasonable. It didn't say that you wouldn't be compensated. Of course you have to be reasonably compensated. So that being so, we thought it was fairly technical, you know, but there was a strong dissent as to whether that mix was right there. And, you know, I thought this is a boring case. No, it wasn't. I mean, none of them are boring, but I didn't think the press would get so interested. So I read the headlines, and it seems as if what they're saying is the Supreme Court decided, take your house and give it to Donald Trump. I didn't think
I'm going to pause here just a moment and recognize a group who have planned their spring break trip from the University of Eastern Kentucky around Justice Breyer's trip and visit to Little Rock. I'd like for their group to stand over here, if you would. We're just proud to have you in Little Rock tonight. Thank you very much.
Thank you.
Thank you. Yes, sir. Thank you.
Thank you, Justice Breyer, for being here. I know that in his confirmation hearings, Justice Roberts said that he thought that the Roe v. Wade case was settled law. I think Justice Alito was a little less definite on what he said. And haven't been keeping up on current events lately, but I have heard that the legislature of South Dakota passed a law related to abortion, restricting it. So I'm not asking you to speculate on a future case. There's no trick question, but I just wonder if you might explain the process of what potentially could happen to a case if someone challenged that law, if it would come up to the court, or how that might transpire. Some people think that that might happen eventually.
Well, the system is fairly simple. I mean, if a law is passed and some people who are affected think it's unconstitutional, they might bring an action, or an action might be brought against them, and then it goes into the court and the judge decides, is it constitutional or not? And then which party it loses, I usually like to say, you know, one lawyer wins and the other one loses. And the one who loses thinks the judge is really, you know, pretty dumb at best. And the lawyer who wins, what does he think of the judge? He thinks nothing. He thinks he's a good lawyer. In any case, the losers will take an appeal and eventually can come up. We have discretionary jurisdiction, and we might take it or might not, and then, you know, there it is. But there's a pretty clear system in the United States which not everyone here or even abroad particularly understand, that when the president or a governor or a legislature or Congress, where they pass a law and there are serious constitutional challenges, we have a system that allows that to be brought. And that's what the judiciary is there for, and popularity, it doesn't really matter, and we then go and do our best to decide it.
Another question, please. Yes.
Mm-hmm.
One of my favorite opinions from the Supreme Court when I was in law school was Flood versus Coon, because of how enjoyable it is to read. Is there any opinion that has been particularly enjoyable, either in the past or one that you authored, that is particularly enjoyable or important?
Well, you're asking two separate things. I mean, Flood versus Kuhn is a baseball case, and that is enjoyable. And so looking at it that way, I have to say that I had a great case that I wrote a dissent in. A great case, maybe the dissent wasn't so great, but the reason I liked it at that level, it involved something about a conspiracy in restraint of trade in prices for dentists and advertising of dental services. And they were talking about Oakland, California, and I could remember going with my grandfather to the minor league games over there. We used to see the Oakland Oaks and San Francisco Seals, and there was a big sign, Painless Parker Dentist, okay? And so I put that in the opinion. I got that, and I said, I don't know what came over me to say that. And there we are. I had that Painless Parker and the Oakland Oaks and the Emeryville Ballpark, and lo and behold, I get an email from a federal judge in Oakland who says, I didn't realize that you were an Oakland Oaks fan. I wasn't. I was a Seals fan. But he said, I've created a website involving the Oakland Oaks, and he sent it, showed me, and there they were, Casey Stengel, and who was the manager of the Oakland Oaks before he went east, and all these great, Lefty O'Doul was in San Francisco. I couldn't remember the names now, but I can remember. I knew, who here besides me knows that Roy Noisley was the shortstop of the San Francisco Seals in 1948. Worcester versus Georgia was decided in the 1830s. It involved the state of Georgia, who grabbed some land belonging to the Cherokee tribe, and gold was discovered. And they said, we don't care about the treaties, we want the gold. And then through a long series of events, that tribe hired a very good lawyer, former Attorney General of the United States, William Wirt, and he brought a case to the United States Supreme Court, and eventually the Supreme Court said, that land belongs to the Cherokees, not to the Georgians. Get out. And that's the case about which Andrew Jackson said, John Marshall has made his decision, now let him enforce it. Yeah. And in a nutshell, Andrew Jackson sent troops, federal troops, to Georgia, and they did not go to help the Indians. They went there to evict the Indians. And the Indians were evicted, and they walked down what was later called the Trail of Tears to Oklahoma, where those who survived, and there weren't many, had children. Their descendants live there to this day. I said, think about that case. Think about what that tells us about the state of law in the United States at that time. Now let's roll the camera forward, and we get to Cooper versus Aaron. And why that's so important is there was a different president, Dwight Eisenhower, and he sent troops right here, because Governor Faubus, at that high school I'd like to see, right here, said, I'm sending my militia, my state police, and those black children are not coming in. And Dwight Eisenhower, President of the United States, said, yes, they are. And he sent paratroopers. See, paratroopers. And the paratroopers took those children by the hand, which I can remember, and they're alive still, some of them. And they walked into that school. What a difference. Maybe we'd learn something at the price of a civil war and 80 years of segregation. All right, so I said, now let's roll it forward a little more, and let's go to Bush versus Gore, or school prayer, or you pick your favorite, abortion. I can promise you that there are in any of those cases a very large segment of the American public that thinks not only is our court wrong, out of its mind, and they feel very strongly indeed. So were there any paratroopers? No. It's an extraordinary thing about those cases, and that is, to me, the extraordinary thing, that no matter how wrong, and we could be wrong, we're human, of course we could be wrong, but no matter how wrong those cases are, this country, they'll do it. They'll follow it. What a fabulous thing. And it isn't the courts that have brought that about. I mean, you could have had 9, Cooper versus Aaron was part of it, but it's a history, and it's a history that gradually shows people accepting the idea that they'll follow decisions that they don't agree with. That's called the rule of law. And it's such an important thing, such an important thing. And that's all part of a long, long history, of which Cooper versus Aaron is a very important part. But it's a continuing thing, and I usually like to say to the lawyers and the others, you can help, it's everybody here. That's the thing we have to pass on.
I hope we're recording all of this. This is just magnificent. Yes, please.
Justice Breyer, I ask this question as an American. I've lived more than half my life outside of the country, over 30 years in Italy. I'd just like to state that I'm very proud to be an American citizen. I'd like to refer to your opening remarks about the importance of the Constitution and, above all, the principle of democracy. And my concern is this: it seems to me that in a true democracy, the majority of the people should vote, not vote. And I just wonder if you consider that Perhaps in the country I live, Italy, a parliamentary democracy, all of Europe, a parliamentary republic, or founded on the principle of parliamentary democracy, where in Italy in the last election 79% of the people voted. Am I living in a greater democracy? And do you feel concerned about the fact that in the so-called greatest democracy in the world, the majority of the people don't vote?
Yes. What can I do?
That's it in a
I can write this book. That's what I do. I want to say that. I want to say that, they said that in the, one of the reviewers said here, and I mean, indeed, that's what but you have to persuade people, he said what the theme is, we don't need activist judges, we do need activist citizens. Mm-hmm. And people can participate in many ways, and I try to tell people, I say to the high school students, which is who I really, I mean, I like talking to you, but I like talking to high school students even more because I say to them, this document that we have, and you begin to feel what it means to the country, and we're 300 million people. 300 million people, and everybody thinks something different. Mm-hmm. And I see that every day in the courtroom. I see in front of me people of every race, every religion, every point of view, and I use the same joke a million times, but it's so true that my mother used to say, there is no point of view so crazy, there isn't somebody in the country who doesn't hold it, and we were in San Francisco, she said they all live in Los Angeles, but the point is there, and this holds us together. And so, of course, the people, so I say to the students, I can't tell you whether to participate or not. I wouldn't think of telling you that. All I'm telling you is this document won't work if you don't. And of course, I am telling them to participate, and they know that. And so I couldn't agree with you more.
Thank you. Thank you very much. I think you've been an inspiration. Thank you.
Certainly have. Yes, right here. We're going to allow this question, and then I have one final question. We'll let you off the hook. You've been going all day long, Justice Breyer. Yes, sir.
Good evening, sir. My question is, the day and age that we live in now with this war that's going on, and of course, it's sad that all these people are dying. It seems to me that in the news that the executive branch of the government has attained a large amount of power. A lot of the public people are really worried about it. They're doing a lot of things that we don't necessarily agree, or how should I say this, constitutional. I don't know if I can ask your viewpoint, or what is the court's feeling on this? As we, the public...
No, you don't have a feeling in this following sense. You have to be careful to stick to your job. And my job is when cases come up involving this kind of thing, I'll do my best to get the cases decided correctly. There's another aspect that I think to what you suggest, which is often overlooked. And part of me, as a judge or someone interested in the Constitution, when I hear people disagreeing very strongly about this kind of thing, or the Patriot Act, or some other thing, I may be the only one in the country, but I cheer when I hear those disagreements, because I say that's what the democratic process is about. There is a process in play, and it isn't totally dead. And what happens, and you get something that's very controversial being proposed, is people have a conversation that isn't always so timid. Sometimes they start shouting. Okay, Tocqueville said in 1840, it's a clamor in the United States. They're all shouting at each other. All right, that's called, they said it was politics then, and it's politics now, but it's politics in a healthy sense. You don't like this, you persuade someone there, you have where does the conversation goes on? In the newspapers, in colloquia, at universities, in journals. Who participates? Everybody. I mean, you have the experts, you have teachers, you have the ordinary citizens, you have the groups, the ACLU or the Sheriff's Association, and they do participate in that legislative process, and then the senator here will try to get a bill he likes, and somebody else might try to amend it, and, or we have administrative rules, and we get some experience, we change it. That is this huge mess, a kind of conversation out of which policy grows in the United States, and the judges work best when they come in at the end, because they're not experts, and their job is not to say what's good policy. Their job is to say whether this system, as it's been decided, is on the constitutional rails. That's quite a different thing. So all that is the process, and when I meet somebody who doesn't like what's happening here or there, or doesn't think it should be this, I say, well, fine, yeah, good. Persuade, participate. And you say, oh, it's so hard to persuade. Well, what's the alternative? What's the alternative? Those people in front of me in that courtroom believing everything else, well, why are they there? They're not in the streets, are they? Fabulous. fabulous. They're not in the streets.
Good
So.
question and great answer.
Thank you, sir.
Let me say, since August the 3rd or so, our fine guest tonight has been a member of the United States Supreme Court, August 3rd of 1994, I should add. 11 and a half years of being on the highest court in the land. 108th Justice, I believe, of the Supreme Court. What lesson, Justice Breyer, if I may ask you, is there a lesson that you come away from after these 11 and a half years of serving on this court in this very exalted position? Do you have something that you would like to impart with us tonight?
I've said
Impart to
most
us
of the
some-
things I believe pretty strongly. As you could see when I talked to that paratroop general, one of my messages was, well, the paratroopers and the judges should be friends.
Yeah.
But there was a message beyond that, and it's a message about the country, and it is a reassuring thing in many ways. It is. I mean, the people are in that courtroom. That's such a reassuring thing. From my point of view, I think it does what all of us feel in the courts, and certainly on my court, that it's a wonderful privilege to be a judge. Wonderful. And what what it's expected of you, and it's a privilege to have this expected, is that we will give our best. That's all. I mean, imagine as you grow older having a job where, well, in a sense, you can't let up. But it's also every minute, I mean, you do your best, and that's it. And it keeps going. That's a rare privilege. That's my part. And then I have the chance occasionally to remind people what they already know. Their part, what is it? It's the transmitting. It's the transmitting, isn't it? That's what we feel as we get older. We say, well, we've had the benefit here, and we've got to pass it on. And that means the habits of understanding the law, understanding the Constitution, understanding the country, realizing that these 300 million people have decided to live together. And we may not like it, all of them, but you know, they're our friends and neighbors, and we better get along with them, we better convince them, and so forth. I live that in my job, and it's just that, as I said, is that wonderful privilege.
Let's give a standing ovation to this great man. Thank you so much. Thank you. Absolutely great.
Thank you. Thank you. Thank you very much. Thank you. Thank you very much.
This has been a wonderful, inspiring evening. Thank all of you for coming, and we're going to be having more of these in the future. We probably won't have anything like it quite as exalting as this. I might say this, don't forget to sign. They're waving these cards at us, so we'll know what to invite you to next. Thank you and good evening. Thank you, Justice.